Thank you very, very much. And a very good morning to everyone. I know we have a very large audience today, and as has been stated, we nevertheless want to try and keep the session as interactive as possible. So for that reason, please do make use actively the Q&A function. Between us, one of us will pick up the questions and try as far as possible to answer the questions live. Now, my name is Carla, and then you have Dominic and Tanya on the line as well. What I'm going to do today, just in less than 5 minutes, is just introduce the topic, introduce who we are, and then I'm going to hand it over to Tanya to take you through the session. Our deck of slides is in both English and Mandarin. So if you have a question, feel free to ask in Mandarin as well, and Tanya will try very hard to respond in Mandarin. I'm putting her on the spot there. In terms of the topic itself, if you look at the title, it talks about collaboration in the time of COVID-19. Now, collaborations are something that a lot of companies do. You may be a company working in manufacturing, you collaborate with a company that provides you with the logistics services, and you go to market together. As in, the logistics services is downstream to you, it helps you get your products out into the market within Singapore and outside. That's one form of collaboration. It's a necessary form of collaboration. It's a vertical collaboration. The other collaboration could be between competitors. So say if you're a manufacturer of product A, and you have a second manufacturer who is also manufacturing product A, and the two of you think that maybe doing a collaboration, be it a joint venture, be it by way of joint purchasing, might be a good idea. And yes, it can be a good idea. But there could also be competition law concerns. And really this session is what is going to go into all of these topics in more detail. So it is about coming together, it is about collaborating, whether it's a partnership, whether it's a joint venture, whether just a friendly handshake, all of these different forms. And on that, the CCCS has issued some guidelines as well, which we will take you through. Now, before we get into the topic proper, just very quick background on the Rajah Tann competition practice as well. We are essentially a firm that operates across Southeast Asia, as you can see on the slide. So our competition practice is also across Southeast Asia. We're not just in Singapore, we are in all of the Southeast Asian countries, plus China. Additionally, we have a network of firms across the world as a whole, called the Lex Mundi Network. The competition team in that network is also very close, and we work quite tightly together. So if you have any issue, whether it's in Singapore, in Malaysia, in Indonesia, in Thailand, Myanmar, or any of the Southeast Asian countries, or further afield, China, India, European countries, and so on, let us know, and we'll be able to help you out on that front. Indeed, right now, I'm working on something involving my Lex Mundi network in China, and we're working together to get the project off, for instance. If I move on to the next slide, just very quickly, this is just a slide of some of the awards that the competition team has won over the years. It's just to give you a snapshot. Moving on into the next slide, some of the very nice comments that people we've worked with have said about the team in terms of how we work together, how we always have the best interest of the client in terms of providing a very business-centric, solution-oriented response to you. If I move on very quickly, this is a slide on me, you can read it later. The next one is a slide on Dominic. I just wanted to very quickly introduce Dominic a little bit more. Dominic historically was an EU lawyer. I say historically because she spent the last 14 years in Singapore. So she has the background of both jurisdictions, which brings a different plate to the table as such. The next slide is a quick introduction on Tanya. Tanya is not a lawyer, she's an economist, and she has worked with the regulators in Singapore previously and has been with Rajah Tann for the last 6 years. Because she's an economist, you know how we are wired differently. She brings a different view as well. So what you see here is just the 3 key members of the Singapore team. We have a larger team as well. Apart from us, we have partners in the rest of Southeast Asia. I'm not going to go through all of them, but just to give you an inkling that we are multi-dimensional. Now, on that note, I think it takes us into the substance of the topic. What I'm going to do is hand this off to Tanya to take you through, and Dominic and myself might jump in as and when. Thank you, everyone. Tanya, over to you.
Sure. Thank you, Carla. Hi, good morning, everyone. It's nice to meet you. And today we'll be taking you through a discussion about COVID, what the regulators worldwide seem to have considered in terms of how COVID affects businesses and might require them to collaborate more quickly in order to deal with some of the effects of COVID. And before we start off, we thought it would be interesting to just launch a poll question or two to seek your views as businesses on how you think COVID has affected your business and affected your strategy in relation to your dealings with your competitors as well. So, Emily, if we could please share the poll questions. There are actually 2 questions there, so you may need to scroll down. This is a very interesting poll, mix of results for me. For question 1, well, I guess less than 1/5 of you think that your business has not been significantly affected by COVID, implying that bulk of you feel that your business have been affected. And one very common and immediate strategy might be to shift more of your business online, launching promotions and price reductions to increase sales. And then there is a smaller percentage that is looking at your agreements with suppliers or distributors, so that those are your vertical agreements up and down the value chain, to see how you might be able to improve the flow of goods to counter the effects of COVID. 0% said that you're looking to share information with competitors. A smaller percentage, 10%, say that you're looking to enter into agreements with your competitors as a result. And that, I guess that's really the crux of our discussion this morning, which is about how businesses can enter into agreements vertically as well as horizontally with your competitors in this time of COVID. And on question 2, interestingly, the responses between whether or not you see increased scope for collaboration and agreement with your competitors, the results are kind of half-half. Half say that you see increased scope for collaboration, the other half say, hey, actually it's now every man for himself. And even compared to before, I'm less inclined to want to collaborate or enter into discussions with my competitors. So I think that's really, really interesting. Thanks everyone for sharing your thoughts.
Tanya, if I may, just very quickly, the one point, and this is before you get into your slides, one point that everyone, 83%, and I know it's 10 out of 12, but still a large number, suggests that they are looking to shifting business online. Shifting business online is a very good idea, except that when you do e-commerce transactions, sorry, I don't know how to put that on silent. When you do e-commerce transactions, there are a number of issues to also consider, and many of the things that will be discussed today will apply equally. And e-commerce transactions, it's not just so simple that I go and set up a website and I start selling. So there are considerations there. And for those of you who are interested, we're happy to take this offline and discuss it further, because there's a lot of buzz, but you need to ensure you do it right. Okay, back to you, Tanya. Thanks.
Sure. So with that as the background, well, this slide is probably something that comes to no surprise to all of you. But I mean, generally, the immediate effects of COVID on businesses has been very significant, both in upstream in terms of the supply chain disruptions. It's been harder to get raw materials. raw materials are more limited in supply. Transportation of those raw materials from wherever they are produced to you has become more difficult with disruptions in transportation, logistics, etc. So that's what businesses have to deal with upstream. And you also have to deal with fluctuating demands downstream. With consumers, customers, it's harder to reach out to them because many of them may not be going out. And that's why many of you have shared that you are looking to shift your business presence online. But that in itself, as Carla mentioned, does raise a certain set of considerations and compliance requirements in terms of how you market online. And I understand from Ellen that SCCCI recently did a talk with the CCCS on the price transparency guidelines that the CCCS has issued. So again, there are other pointers to be mindful of as you're shifting your businesses online. But dealing with fluctuating demands, launching promotions to ensure that you can continue to clear stock, that is also something, a byproduct that we have seen very commonly amongst businesses. So this looks like a very, very busy slide, but on this slide we have just painted or put out there some of the immediate effects that we have seen, and through our discussions with clients and some of the projects that we are working on, we see that COVID has resulted in disruptions in the supply chain, as we talked about. When we read the papers, we see that there have been closure of businesses, a reduced number of players, industry consolidation as well. So I mean, other than these being facts that we are very familiar with as consumers, they also have an impact on competition law insofar as they reduce the number of players in the industry and make it more likely that certain stronger players in the industry may have dominance, and therefore their actions are more likely to have an impact on competition in the market and also be scrutinized by the regulator. So for all these industry trends, there could be competition law implications. And we also see in the clouds in Lion over there, suppliers taking action such as increasing the prices of goods in demand, launching aggressive customer promotions to attract customers, maybe having tying and bundling promotions to increase sales. Again, these do have implications on competition law because if you're a player with market power, some of these actions may be regarded as anti-competitive or exploitative, or exclusionary to drive out your competitors during this difficult time. And then we do see in the boxes in green at the right, we may have businesses that are looking to enter into joint purchasing agreement, setting up joint ventures, having vertical agreements with your distributors or your suppliers. And those are also agreements with and collaborations with other players in the industry and along the production chain, which we'll be discussing today. And of course, other implications such as having more conversations with players in the industry, perhaps increased sharing of information between you and your competitors in order to facilitate flows and the reaching out of consumers, as well as the provision of essential goods to consumers. So we'll be discussing many of these during the session today. And of course, if you are facing any unique situations or want to share personal examples or really very concrete examples based on what you are doing, please feel free to do so anytime via the Q&A function so that we can really discuss these as they apply to you. And of course, then we do see analysts saying that, oh, because of the COVID-19 pandemic, it really calls for greater collaboration and business transformation. And that's really, the idea behind the talk today, as well as the guidance note issued by the CCCS in recognition that businesses may need to jump in more quickly to enter into collaboration to deal with certain disruptions, and may want to know where the OB markers are in terms of what they can or cannot do. So with this, these are some of the questions that we have received before, and we thought some of it might be relevant to many of you. So thoughts like, due to the scarcity of raw materials, Can I agree with my competitors that we each limit the amount of raw materials we order so that there is enough for everybody? Or can I then agree with my supplier that he will not supply my competitors, right? Because raw materials are in short supply. Is it possible to enter into exclusive arrangements so that I have my share and my competitors don't? How about to ensure that no customers are left unserved, which is really something that we want to do for consumer interest and consumer welfare? Can I collaborate with my competitors and designate, who to supply which customers in order to ensure that we reach out to everybody? How about other questions like, to offset price increase of raw materials, can I agree with my competitors to pool together our orders to enjoy volume discounts? Or pool my delivery services with those of my competitors? And we do see that, for example, with some of the hawker apps, if you buy from this stall, they might also help to deliver food from the other stall so that you get a complete meal. How about questions like, COVID has made it very difficult to sustain businesses in my industry. Can we actually limit production so that there's a lower quantity of goods out there and prices go up so that our business can survive? Or how about signing a 5-year, joint marketing agreement with my competitors? If the government or governments worldwide seem to suggest that collaborations are okay, is it acceptable for me to then sign a 5-year agreement to deal with the effects of COVID? So these are the questions that, some of you may be having, and we will discuss them in the course of the presentation this morning. So with that, we will go into the general framework. First, take a few steps back before we talk about, why competition law comes into play in the discussion on collaborations between competitors. Let's just take a few steps back to see what competition law generally has to say about collaboration between competitors. With that, I'll hand over to Dominic, who will take us through this part of the slides.
Hi, everyone. Yeah, we just wanted to give you a little bit of background and as Tanya mentioned, one step back. As you know, the CCCS enforces competition and consumer protection in Singapore. On the competition side, we have the regulation of market behavior, so anti-competitive agreements and abuse of dominance, and then the regulation of market structures, so mergers or amalgamations or the setting up of joint ventures between businesses. All these come under the purview of the CCCS, and protecting consumer interests, which has come under the purview of the CCCS since about 2 years, more than 2 years ago now. What we are going to focus on today is the very first square block in this slide, which is anti-competitive agreement. Anti-competitive agreements. When we refer to agreements under the Competition Act or in competition law generally, this applies in Singapore as well as elsewhere. We do not talk about agreements like a contract under contract law. We talk about any kind of understanding between businesses. It can be a formal agreement, but it can just be a mere understanding. It can be an understanding coming out from exchange of messages and WhatsApp. It can be a discussion and shaking hand at the end of it. It can be a decision by a trade association. So it covers a number of instances where business just agree on something. As an illustration, there is a current cartel case where most of the evidence was through WhatsApp exchange, for instance. So agreements or concerted practice that have the object or effect of restricting competition in any market in Singapore are prohibited. Carla mentioned collaboration, so did Tanya, vertical collaborations and horizontal collaboration. Horizontal collaboration, horizontal arrangements are agreements between competitors. When competitors come together and reach some kind of understanding on the price or any element of the price they will charge, or fix their production volumes or fix quotas, or agree on who is going to respond to a tender, or at what level of price a bid would be put in, or where competitors agree that one will sell its products to customers in the east of Singapore, while the other will deal with the customers in the west of Singapore, which is market sharing. This is a strict prohibition, a strict infringement of competition laws in Singapore. When there is price fixing or the sharing of markets, for instance, whatever the market share of the competitors, it is a problem. So even if you are very small, and if 3 competitors come together, they maybe have together 10% market share. If they decide to fix the prices of their products to customers, this is in anti-competitive agreements. Vertical agreements for now are excluded from the anti-competitive agreements prohibition unless one of the party has market power. This is very unique in Singapore. And if you just look at your neighbors, Malaysia, vertical agreements can, or restrictions in vertical agreements are prohibited for some of them. Now, does it mean that when you are competitors, you cannot cooperate? No, of course not. So there are various exemption or exclusion under the prohibition of anti-competitive agreement. The one we are concerned with today is net economic benefit. Net economic benefit is where competitors come together and their agreement will improve production, distribution, or promote technical or economic progress. So they have to agree on certain things. Maybe they need to price fix, and I will just give you 1 or 2 illustrations. So there are restrictions of competition, but the benefits flowing from the cooperation, from the collaboration, outweigh the negative impact on competition. And for that reason, these kind of arrangements are authorized, are not in breach of the Competition Act. So just giving you maybe 2 very quick examples. One is just because, as all of you, I guess, I miss flying. So one obvious illustration are cooperation amongst airlines. So less than 5 years ago, for instance, there was a cooperation between Singapore Airlines and Lufthansa, and they agreed on the prices, well, just to coordinate their flights between various cities in Europe and Singapore, or destination out of Singapore in Southeast Asia. There are competitors, 2 airlines, they were flying the same routes, and they decided for efficiency to, and I just make it simple, to come together and then share. So they decided, they share the slots on their flights. They would agree on the price that would be charged to customers for certain flights, on certain routes. This anti-competitive, yes, on the face of it, they allocate market, they fix prices, yet it allowed for efficiency, for a better service to the consumers in this case. And this cooperation was found to result in net economic benefit. There was an application made to the CCCS at the time, and the CCCS authorized the cooperation with some commitments, but generally authorized it. So this is one form of cooperation. Another form of cooperation would be something like Pay Now, for instance. So you have banks coming together under the Association of Banks of Singapore. They are competitors, and yet together they offer a service to customers, to consumers, which allows for a quicker adoption of cashless payment, for instance, and makes transactions secure and easy to the benefit of everybody. This again would be an arrangement between competitors which produce net economic benefit. The importance of the net economic benefit is something that obviously came up when we entered into this COVID-19 situation, and where it has become necessary in some instances, and Tanya will provide more examples on this, for competitors to cooperate. It was also important for the businesses to have some kind of guidance or kind of safe harbor by the regulator to better understand when and how they could collaborate without risking infringing the Competition Act. On this, I hand it over to Tanya so she can go into very specific examples linked to the COVID situation. Thank you.
Thank you, Dominic. So I think one point that is useful to highlight and emphasize is that the concept of net economic benefit has always existed under the competition law framework in Singapore and in most other countries. So whilst the CCCS has issued this guidance note that illustrates with more examples as to what is likely to fall within the camp of agreements with net economic benefits, and therefore the CCCS is unlikely to investigate further during this COVID pandemic. It's important to bear in mind that actually these are general principles that have actually always been there and would have continued to apply with or without the guidance note. And it's really for businesses to sit and really consider before they enter into a collaboration whether or not your agreement or collaboration would fulfill these three criteria here. And we'll be discussing that further along the way and how it applies to collaborations during COVID. So the CCCS issued its guidance note in July. But before that, and as it continues to take place around the world today, many other jurisdictions and competition authorities have similarly also issued some form of statements or guidance on how they would treat collaborations during this COVID-19 pandemic. Again, recognizing that there have been various disruptions to businesses during this time. Businesses may need to take fast action to try and mitigate these effects in order to continue production of essential goods or to ensure that essential goods are able to reach consumers. So just as some very quick examples, sorry, let me just bring up the whole slide. So as Dominic mentioned earlier on, the overriding principle really is that coordination between competing businesses are generally prohibited, because competition authorities take the view that without more, you shouldn't quite be talking to your competitors, exchanging information with them, or coming to any cooperation with them in relation to how you get your supplies or how you market to your customers. But in recognition that COVID-19 has brought about certain unprecedented issues, collaboration has been allowed, sometimes under certain frameworks, sometimes, as in the case of Australia, subject to interim authorizations in which the competition authority in Australia would allow certain types of collaboration. I won't go through each of the boxes on the slide, but some, general common points between them is that, hey, yes, authorities recognize that businesses may need to collaborate during COVID, but certain, and even though they will take a more lenient approach towards assessing such collaboration, there are certain strict no-nos which fall outside this automatic or more lenient treatment. And that is collaboration in terms of prices. So like you will see, price coordination is generally not allowed between competitors. Related to that, not only are you not allowed to, really fix prices, the direct sharing of information relating to costs or prices are also not allowed. Not allowed to share information on future business strategy. And generally, businesses shouldn't be using COVID as a cover or an excuse to enter into collaborations that are really not related to difficulties brought about by the COVID. What authorities have generally pointed to is that agreements that relate to joint production, joint marketing, insofar as they allow you to get your goods more easily to consumers or get your supplies, are generally okay if there isn't the exchange of commercially sensitive information. And some authorities like Hong Kong have said that they're willing to, understanding and recognizing that businesses may be quite uncertain about what is allowed or not. The authority will be willing to review and provide informal guidance as to whether or not the proposed collaboration is okay. So just to share an example from Australia, the ACCC has authorized supermarkets to continue cooperating on COVID-19 response. As I mentioned earlier on, the ACCC has introduced a framework of interim authorization, whereby they will review an agreement and kind of, provide its view on whether or not it will authorize such collaboration. So important to note is that even in this authorized collaboration, there are only a very narrow set of collaboration is allowed. In particular, the supermarkets, even though they are authorized to collaborate, such collaboration and such authorization does not extend to the coordination about the prices of the retail products. The scope of the authorization is really to enable supermarkets to discuss and enter into contracts more readily and easily for the purposes of ensuring the supply and fair distribution of retail products to Australian consumers during the pandemic. So this ties back to the point that Dominic mentioned earlier on about, having to have a benefit to consumers that override any potential anti-competitive effect. And in this case, it's about improving distribution of essential retail products to consumers. Doesn't relate to price fixing. It's only a temporary measure. And it's really to deal with, and what we have seen as well in other parts of the world, stockpiling behavior by consumers, whereby consumers may rush out to buy certain types of products, and there's then a shortage for selected retail products, which this authorization and collaboration is intended to overcome. So that was the global and international picture. In Singapore, as we mentioned earlier on, the CCCS has also come up with a guidance note. This was issued in July 20 on how they would view collaborations between competitors in response to the COVID-19 pandemic. So the CCCS in its guidance note has kind of laid out 3 clear criteria for businesses to consider. Sorry. Well, we have received a question, so I thought I'll just read it out and try to address it along the way. So why cooperation is better business than competition? Why might businesses want to cooperate rather than just compete? Well, as can be seen from this slide, one of the criteria that the CCCS requires for a collaboration that is more likely to benefit from the NEB criteria, and which they say that they would then presume that such agreement has net economic benefits, and therefore they will not investigate further during this period, is an agreement that relates to the supply of essential goods and services. So if you link back to the Australian example whereby we were talking about the retail supermarket products, here it's also about getting certain essential goods and services to businesses or consumers. And the CCCS has drawn on the list that is published by the Ministry of Trade and Industry. There is a list of the essential goods and services. I won't go through all of them because it's a relatively long list, but it relates to industries such as health and social services, food, transportation, financial services, telecommunications, manufacturing, finance, and others. Carla, you wanted to add something?
Yes, Tanya, thank you. Just to pick up on the question that you highlighted from Ken, why cooperation is better business than competition. I just wanted to provide a slightly different perspective as well. Everything Tanya said is accurate, but just very short, simple answer would be not always. I know cooperation is not necessarily better business than competition, because you can be two small businesses, two small SMEs, and if you compete together, when you compete with each other, it means that downstream players to you, so be it your distributors, your retailers, whatever, as well as end consumers will always have a choice. So competition is always better, but yet sometimes when market conditions are difficult, or you have a strong supplier, for example, or a strong buyer downstream, for example, coming together to cooperate can help build synergies. So this is not just during COVID, it's also outside of COVID period, where if you can have very good reasons to show that you're building synergies with the end result that it will reduce overall pricing, for example, to consumers, that's a good reason for collaboration, but it must be carefully thought through. So in the COVID scenario, in addition to some of the examples that have been cited, one of the things that happened in the UK supermarket scene, for instance, employees, the drivers by different supermarkets, let me phrase it a different way. Each supermarket had their own fleet of drivers to send off produce to various downstream players, for instance. What the UK Competition Authority, the CMA for short, Competition Markets Authority did was to allow the supermarkets to come together to have one driver, even if he's working with supermarket A, to deliver for B and C too. And that means that some confidential information is being exchanged. But on balance, it meant that in a COVID scenario, amongst other factors, it was reducing the number of people in public. It was ensuring that service continued and did not get disrupted, just to give you two reasons. So the question looks simple enough, but there are pros and cons to cooperating, and basic rule is go and compete. But if there are really good reasons to cooperate, let's come and cooperate. So just wanted to put that out there as well. Thank you.
Thanks, Carla. So the first criteria would be that the agreement should relate to the production or supply of essential goods and services. The second criteria is that the CCCS has kind of imposed a time-bound limitation, whereby they say that they will not scrutinize agreements that are, that fulfill the other criteria and are limited in scope and time, being that they are put in place from just February this year, and the agreement should end by 31st July next year. For agreements that are actually longer than that, means they may have started in March, for example, this year, and ends by, let's say, December 2021, the CCCS is going to treat it as being out of the entire duration and the entire agreement as being out of the scope of what is in their guidance note. And such agreement should not involve price fixing, bid rigging, market sharing, or output limitation. If they do, and as Dominic mentioned earlier on, these practices are more likely to have anti-competitive effects, and therefore will require greater scrutiny by the CCCS before they determine that the NEB exclusion or the net economic benefit exclusion applies. So then going back to Ken's question and what Kala had said earlier on, from looking at some of these criteria, we do get the sense of why the CCCS thinks that certain forms of collaboration and coordination may be more beneficial than competition, especially during this period. But like Kala mentioned, and what the authorities have been very, very clear to point out, COVID is really not a blank check for collaborations. And in particular, when the authorities do this balancing and weighing exercise as to whether competition is better or cooperation between businesses is better, they will look at factors such as the benefits. So how does it actually improve the supply of goods? And in this case, a narrower focus on essential goods, because we don't want to have open the door to all forms of collaboration, even in goods that are not essential during this period or that are not affected during this period. And when authorities weigh this, they also look at the scope of your agreement. What does it involve? Does it involve elements of price fixing and bid rigging, for example, which is generally regarded as having more likely to have competition harm, as well as the time period. And with all these, can you argue that your agreement is really essential and doesn't restrict competition to an extent that is more than necessary? So that's really some of the factors and what makes it interesting in that weighing exercise and trying to evaluate whether competition is better than coordination. We do have another question, and I'll seek to again answer this along the way. Am I right? As long as the collaboration is not on price fixing or supply fixing, the collaboration is considered okay. So this is a very good question and really ties back to what the CCCS has been has tried to do when they put out this guidance note. Is that yes, if it doesn't involve price fixing, market sharing, etc., it's more likely to be okay. But there are also the two other criteria that need to be fulfilled in order for the business to have a certain degree of comfort that the CCCS is not going to look at it. And that is that the agreement must be limited in time. So it should not extend beyond 31st July. And it should relate to the supply of essential goods and services. So to that question, even if your agreement doesn't relate to price fixing or market sharing, for example, if the duration is long, so it goes beyond 31st July, it's not necessarily okay. And if it relates to other types of goods and services other than what is listed in the annex of the guidance note, then it may not be okay as well. May not be okay doesn't mean that it's not allowed, but it just means that businesses cannot just assume that the CCCS is going to say that NEB exclusion applies. And then we do have another question. How about collaborations in non-sales function, such as fulfillment and operations to reduce costs? Are they okay? So this is another good question. As we have seen from some of the guidance provided by the other competition authorities, really it's information about pricing information and cost information that tends to be more sensitive in relation to having anti-competitive effects. Collaboration in non-sales functions, such as maybe joint production, joint marketing, they are less likely to be anti-competitive. And I'll go through that later on in my slides. But again, it's not so clear-cut as to say that, okay, so long as it's a non-sales function, it's going to be allowed, because it then needs to tie back to the criteria, and the business should ask itself, no, is it really necessary in order to achieve that benefit that we want to, that we need in order to improve production and distribution? although it's a collaboration in non-sales functions, are there other sensitive information that is being exchanged that actually goes beyond the scope of that non-sales collaboration? And how is it really being done? So these are questions that the businesses still need to consider, and we'll go through in the subsequent slides. So this goes back to that question. So what are some of the examples that have been listed in the guidance note, which generally should be okay if it fulfills the 3 criteria? First is joint production agreements. So, and the example given in the guidance note is agreements to share production lines or input to increase production of essential goods. So again, this is generally okay if it relates to essential goods and is limited to time and scope. And an example really would be to share production lines, for example, to increase total production of testing kits, right? In order to increase production and increase capacity, similar to the example of airline collaborations that Dominic spoke about, whereby airlines may have certain reasons and good reasons to want to enter into coordination agreements so that they can make use of spare capacity, right? Instead of 2 half-empty planes flying, they collaborate and then they have 1 full flight in order to reduce wasted capacity. So similarly, in the context of production during COVID, I mean that same principle can apply. If they coordinate and share the production lines, it's possible that they can increase greater output. There is less downtime, there is less spare capacity because you are running a machine at full capacity in order to produce for 2 companies. And in such case, I think there is a strong argument to be made that such joint production agreements has net economic benefits, improves production, so long as no further very sensitive information is being shared, or if that sharing of information is done through a neutral third party, that would also reduce competition concerns. And again, that the timing and scope of the agreement must be limited. It shouldn't be, let's say, in the examples that we spoke about earlier on, a 5-year agreement to deal with the effect of COVID. Another example would be a joint distribution or marketing agreement, which allows companies to pool together resources to appoint a third party to collate and distribute essential goods on behalf of parties. So this goes to the example that Carla mentioned earlier on about supermarkets and how they may collaborate to improve delivery. In Singapore as well, we have seen that with the hawkers, like I mentioned. There's actually it's not just delivery from one shop, but the delivery services can extend to delivering hawker food from several different stores. We have also seen that with some of the announcement in the news about how we do have some of the private hire delivery drivers helping to deliver for supermarkets and so on. So it's really pooling resources, making use of spare capacity somewhere else. There's a lower demand for private hires for passenger purposes, and we use that in order to facilitate and move them to delivery of, let's say, supermarket products, for example. So that's another example that is highlighted in the guidance note as being, more likely an agreement that will benefit from the net economic benefit exemption. So other examples would be joint purchase agreements, which also includes the concept of collective bargaining, which means that when 2 companies, they put in an order together, they're more likely to benefit from having a bigger order, potentially volume discounts, potentially reduces the cost of delivering the inputs to the 2 companies. There are also lower transaction costs, for example. So in such case, a joint purchase agreement can lead to economic benefits. But as with all of this, we just have to be very conscious about, although we call it a joint purchase agreement, are we actually using that agreement to exchange information that doesn't need to be exchanged, or that when exchanged may actually have an anti-competitive effect. So for example, a joint purchase agreement could actually give an indication about a company's strategy, right? If I buy 50 units and I know that my competitor is also buying 50 units, does it give an indication that, hey, we are producing roughly the same quantities? If we produce 50 units today, we purchase 50 units today, and we say we are going to only purchase 30 units tomorrow, does that give some kind of indication as to our strategy, our future production plans? And where such sensitive business information can be discerned or maybe exchanged through joint purchasing agreements, then we would caution that actually, be careful about how these agreements are structured. Do the information exchanged through a neutral third party, which can anonymize the information if possible. So for example, if it's done through a third party, could be that the third party knows how much each company is getting and how much each company intends to produce, but each of the companies do not know who is actually ordering this amount or that amount. They just know that combined they are ordering this amount and they get to enjoy certain discounts, volume discounts. So same with information sharing. So when you share information of each other's quantities of existing stock, make sure that you implement safeguards to ensure that the sharing of information does not inadvertently lead to price fixing. We just wanted to put this out there because that may not be the intent, but depending on the type of information that is being exchanged, how sensitive it is, how it is being exchanged, who in the competitors will have access to the information. When a third party or when a competition authority looks at that agreement, they may say, hey, on paper it's a joint purchase agreement, but you are in effect sharing information that can actually lead to price fixing, market sharing, output limitation or bid rigging. So it actually falls outside the scope of the guidance note. So that's just something to be mindful about. And another point to note is that, and Dominic mentioned this earlier on, decisions of associations would also fall under the Section 34 prohibition on anti-competitive agreements. So during this period, it could be that associations are having more meetings to discuss, COVID has had this effect on the industry. We would encourage, or we would suggest that companies do this or do that, or they may survey companies during the association meetings. Hey, what has been the situation? What has been your experience? What are you planning to do? And so these discussions that take place at industry association meetings, insofar as they relate to things like price fixing, sharing of very sensitive information, market limitation or market sharing, that would seriously raise competition concerns, and we will alert businesses to continue to be very careful about what you share during your association meetings during this period as well. So then a question that you may have, after hearing about the 3 criteria that we spoke about and the various examples of the agreements that the CCCS has said is okay, you might be wondering, hey, what happens if my agreement does not meet all the criteria? What if it involves, the 4 types of more sensitive conduct like price fixing, output limitation, etc.? Is it automatically disallowed and prohibited, and I shouldn't even think about going there? Well, the answer is no. Because what the guidance note just means is that where it doesn't relate to these 4 types of behavior, and is limited in time and scope and fulfills the other criteria, businesses can be more assured that it fulfills the net economic benefit criteria, and the CCCS will not investigate further. But it doesn't mean that you can't engage in other essential collaborations that entail some elements of output limitation or market sharing. But that is really something to be very seriously considered. especially with respect to the justifications for it. And we would, that you can't assume that that is kosher, and you do need to, we would encourage you to speak further with advisors or even approach the CCCS to get more guidance in this regard. We do have another question. I think I'll finish this slide before I address that question. So then the second question would be, hey, you mentioned that only agreements operating within the stipulated time frame of up to July 2021 is okay. What happens if my agreement goes beyond that? As I mentioned earlier on, if the agreement goes beyond the July 2021 time frame, then it doesn't automatically fall within the exclusion, and the CCCS will look at the agreement as as any other regular agreement that falls outside the scope of the guidance note. Doesn't mean that it cannot take place, but you do have to think about, why you would need it to go beyond 2021. Is there any way to structure it such that the first phase of the collaboration falls within this period, and then after that, parties look further and consider whether or not they would like to extend the agreement, and in which case it was, only that second phase of it falls outside the scope of the guidance note and needs to be further assessed. And what if the goods or services falls outside the stipulated list of essential goods and services? Then we would encourage companies to think, hey, is there any relevance to the COVID-19 situation at all? As we mentioned earlier on, the list of essential goods and services, there are quite a number of them. So do see whether they might fall within the list. And if they are not, really consider whether or not it has anything, it is linked to the COVID, and how you might be able to argue as such. So the question that we have received says, we are seeing more consolidations around. Are there implications for JV and M&As during this period and going forward? I think that's a very, very good question, and certainly one related to competition law as well. On one of the first few slides that Dominic mentioned, went through earlier, you have seen that we have that prong on prohibitions against anti-competitive agreements. We have a prohibition against abuse of dominance. There is also a third prohibition against mergers and acquisitions that substantially lessen competition. So as we see consolidations going around during this period, two companies combining to become one, or one company buying over another, inevitably it means that there will be fewer market players left in the industry. The industry will become more concentrated, and with the result that, that would lead to a lessening of competition. Because where there were, let's say, 5 players in the market before, after all these consolidations, you only see 3 maybe, or 2. So competition will be restricted. The question then is whether or not it is a substantial lessening of competition. So, businesses and the authorities will consider, hey, who are the 2 players coming together? Are they the 2 biggest players in the industry, and by coming together, they will substantially lessen competition in the market? Or, hey, is one of the firms, a failing firm and would have exited the market? And so by allowing this consolidation, there's actually a net benefit to the economy because there's less disruption to customers. And there is no substantial lessening of competition because even without the merger or acquisition, that failing firm would have left the industry anyway. So there are certainly implications. And at this point, I should just also highlight that although Singapore has a voluntary merger notification regime, it's up to companies to self-assess whether or not their transactions are likely to lead to competition concerns, and to then get a clearance from the regulator before proceeding with their transaction in order to ensure that it doesn't violate competition law. So if you are one of the companies that are considering entering into a consolidation or a transaction as a result of COVID, do bear this in mind, that we do have this merger notification framework. Businesses must consider what is the likely impact of their transaction on competition in the market post-transaction, and consider making a notification to the CCCS where there is any doubt that it could cause competition concerns. And with that, many of you might be familiar with the Grab Uber acquisition that took place some years back. So in that case, the CCCS did investigate and look into the transaction, although it was not notified to the commission upfront, and various measures then had to be implemented by the parties after they have entered into their agreements in order to address the competition concerns of the CCCS. So the CCCS does have power to do things like unwind transactions, impose measures and directions that would affect your transaction. So it's always better to get that clarity up front before you go into that transaction. Dominic.
Yeah, I just wanted to add in relation to consolidation, because as we were going through the potential collaborations amongst competitors in times of COVID, when it comes to mergers, the competition concerns that can arise from a merger are not only in a case where a company buys over its competitors or invest in its competitors. So it can, for instance, be kind of vertical integration, a supplier buying over a distributor. And there may be efficiencies to this. It will have access to the retail market directly, for instance. But if the distributor or the supplier manufacturer is big enough, and we are not talking about dominance here at all. So it's not the 50 or 60% market share, it's much lower than this. And if this consolidation, this vertical integration mean that the competitors of the supplier, for instance, of the manufacturer, will have a more difficult access to markets, to the retailers, or that other distributors will have more difficulties to have access to the manufacturer's products or service, then it can be a merger that substantially lessen competition. In the CCCS is reviewing a number of its guidelines currently, including one on the assessment of mergers, and they have emphasized that it's not only horizontal mergers that are an issue. It's not something new. They had said this before, but yet they have emphasized this again and provided some example of issues that can arise from vertical mergers or even conglomerate mergers. For instance, a manufacturer of drinks who buys over a manufacturer of some kind of food products. That could be a conglomerate merger. So just wanted to highlight this point on consolidation.
Hey, Tanya, just to add on to what Dominic has said as well, if I may. Now, when we talk about consolidations, and I may have missed it, but just to be very clear, mergers is a very important area. The mergers is where the two companies are coming together effectively to operate as one. But remember, collaborations and joint ventures may be a merger, but they may not be a merger, meaning that the 2 or 3 or 10 companies coming together to collaborate, or as a trade association, all trade association members come together to collaborate, or even sometimes to form a joint venture. That's not necessarily a merger. So the rules, as my fellow partners have described, in relation to Section 34 will continue to apply, meaning it's anti-competitive unless you can show net economic benefits. What that means is you need to show that the benefits basically outweigh the competition, negative competition effects. Now, one way you can get comfort is to go to the CCCS to apply for what we call a decision or a guidance. The guidance is confidential, the decision is public. So a lot of airline alliances do that. And what they get from the CCCS is a comfort decision saying that, yes, go ahead and collaborate, not a problem as so long as you're doing it in this structure. So that's again something that you might want to think about. Now, what I'm saying here applies to the large corporates, but they also apply to the medium-sized corporates, the smaller corporations as well. So you might be operating small mini marts, but the 5 different mini marts want to come together to do a deal. It may be something to think about. In real an example, and Dominic will correct me if I'm wrong, most recently we had a few chicken distributors come together and form a joint venture where they had all of their slaughtering done at one place. Now, there are potential anti-competitive issues that come out of that. So what they did was to get a comfort by way of a decision rather than a merger clearance from the CCCS, so that they can go ahead and cooperate that way. So it's a bit technical what I'm saying, but if there are businesses out there and you're thinking about doing cooperations, pick up the phone, check, you pick up the phone with the CCCS, they're not going to give you a straight answer immediately. They will want a lot of facts. But pick up the phone, call Tanya, myself, Dominic, just for a quick chat, quick check. We're always happy to do that for you. Thank you.
So with that, we just wanted to share a few, I guess, final tips or suggestions. So when you're implementing the collaboration, as we mentioned, businesses should always be doing that self-assessment, matching against the 3 criteria that the CCCS had put in the guidance note. Of course, if it squarely falls within the 3 criteria, relating to essential services, doesn't involve price fixing, etc., limited in time and the agreement ends before July 2021, yes, generally you can proceed, knowing with the comfort that it falls within the guidance note and the CCCS is unlikely to investigate. But sometimes it's not so clear cut, and that's maybe, hey, maybe it fulfills, maybe not. I have questions about whether or not the guidance note really applies to my proposed collaboration. So that's where we Kala suggested, maybe just calling somebody up to just seek, go through that self-assessment process and to seek confirmation on, hey, on balance, is it likely, to fulfill all 3 criteria of the guidance note? Is there anything that you need to be concerned about? Is it generally okay, but certain parts of the collaboration may need to be tightened or the scope a bit reduced to fully remove any competition concerns at all? So sometimes it could just be a matter of how you structure the agreement, what types of information is being exchanged, how it is being exchanged, that can kind of push the agreement one way into the green versus one way into the other way into the red. And of course, the third possible outcome of your self-assessment is that, no, it doesn't actually fall within the 3 criteria. But, no matter what, I still think that my agreement results in net economic benefit, right? There's that wider net economic benefit framework outside of the COVID guidance note. And here, I think my agreement actually fulfills the 3 criteria. It ends after 31st July, but hey, I think it still falls within the criteria. Then again, we would encourage you to, speak with us or someone else, and then also decide whether or not to apply to the CCCS for guidance or decision. This is what Kala mentioned a few minutes ago as well. A process that can, through which you can get that comfort or that guidance or decision from the CCCS formally. And some simple do's and don'ts. So, when in doubt, seek advice before implementation. We would also encourage you, because, the sharing of information, any form of collaboration would necessarily involve some sharing of information. To further reduce the risk, we will encourage, to carefully think through how the information exchange is being conducted, who is sharing the information, who receives that information. So where possible, to set up Chinese walls to isolate the information flows to a limited team. So even if you're sharing information about, let's say, your costs, for example, but it is kept within a limited team. Let's say sharing information about your production capacity. But it's shared with a very limited team of people or third parties so that your competitors cannot use that information to influence what should be their independent production decisions. Then that would reduce the competition risk. The third one would be to really do that self-assessment, record evidence of quantifiable efficiencies. And that's why we really encourage companies to do that self-assessment and actually, document it somewhere, because if and when your agreement is being investigated by the CCCS, the burden is on you to prove that your agreement fulfills the criteria and has net economic benefits. So if you have gone through that process, you have documented, how you think this would have improved distribution, increased production of essential goods and services, etc. This makes it easier for you to justify your conduct, and hopefully the investigation can be closed at an early enough stage with no issues at all. And then, of course, when you're meeting with competitors, other players in the market, attending a trade association meeting, as always, we will encourage that you take very comprehensive notes of the meetings, right? Because in the course of an investigation or an inquiry, it's what you can rely on to show what actually happened, and qualify that discussions are preliminary until you have conducted a further assessment on competition. So it could be that you're meeting your competitor, another market player, and thoughts of having some form of collaboration comes up during the meeting. We will encourage that you don't share too much information at that point in time. You can discuss potential ideas, qualify that these are preliminary, and then go back, do a self-assessment before proceeding further. And of course, the strict no-nos would be to concurrently share information or make arrangements unrelated to essential goods or supply. This is a common point that really comes out of all the competition authorities' guidance on this matter. Do not use COVID as a cover for other forms of collaborations that are completely unrelated. And do not enter into collaborations for a longer duration than necessary, especially in the case of the guidance note, which stipulates a very fixed date. Consider how you can structure your agreement such that it is limited in the first instance. With that, we have come to the end of the presentation. Thank you very much for having us. To Emmeline and the rest of the team at SCCCI to say, thank you for having us, and we hope this was useful.